So before we understand the criticality of criminal law and then try to understand the dialogical approach and how do we measure this dialogical approach to the criminal law in the Indian context, let's try to understand what is it all about criminal law. We all understand is a criminal law is a branch of law, and as Professor B.V. Pandey always used to say, it is a species of moral and political philosophy. And if we try to understand criminal law in the context, the whole branch of study is full of paradoxes. And because for its very much its reason being that it encroaches upon the fundamental freedom of an individual, and somewhere it always depicts a power relationship wherein your fundamental freedom, your personal liberty, your life would be threatened with the implementation of the provisions of criminal law. So it's the power relationship is deeply pervasive in this branch of law, and it's always being imposed in the name of social conscience. So this is because we always feel that this is a means of social control. So having these kind of an understanding, if we try, whenever we are trying to teach criminal law, what do we do basically? Almost in all the law schools, the way in which we teach criminal law, we teach a normative framework, you know, and we always try to justify criminal law, and we teach criminal law as a utilitarian tool. And we believe that criminal law is the most important branch of law. If even for one day the criminal law is not there in existence, probably there'll be hue and cry. It is the most important means of social control. It makes the society an orderly situation. So we always try to look at criminal law as an utilitarian tool, and mostly we teach criminal law as an insider who is a part of the criminal justice delivery system, who is a part of this domain, and we teach them. We never try to just step aside of the circle, outside the circle, and try to look at the criminal law as a third party. So most of the times, as a teacher of criminal law, as someone who is the part of the justice delivery administration, we try to and we tend to ignore all the external factors. And that is the reason that we sometimes, and most of the times I would say, we oversight law and context. So this is something which is a big gap when we deal with the criminal law, and when we are trying to promote the critical issues of criminal law, when we're trying to design a course, when we really want to have invite a discourse and discussions in our classroom with the students on critical issues, probably what we basically require to do is that we try to see and narrate the law in context. And most of the times we underemphasize the rational, that why do we punish, what is the purpose of punishment, what is the purpose of criminal law, to whom criminal law is addressing, whether criminal law is serving any purpose. Despite of having a plethora of laws, whether the crime rate has been any day decreased, whether the criminal law has any kind of a deterrent effect. So these kind of questions are very much there. But we sometimes oversight, we do not give an adequate emphasis on these kind of questions, and we underemphasize the rationale of criminal law. So and we whenever we try to ponder upon these kind of an issues, probably we are getting into the criticality of criminal law. So when we talk about critical criminal law, I feel that it highlights the philosophical reflection on the fundamental aspects of criminal doctrines, and specifically we try to discuss and deliberate upon the punishment. What are its justification? It covers the aspects of justification, limits of criminal law, over criminalization, and uh, the fundamental and core part of the critical criminal law is that we question the legitimacy and the rationale of criminal law. And how do you rationalize criminal law as an instrument of state power? And there has been a lot of writers who have written on these aspects. We have an historical function. We all had Professor Alan Norrie just before this session. He has one of the he has written extensively when it comes to the historical approach of the critical criminal law. Then we have a functional, normative, and societal critique of the criminal law. So basically, the core aspects of criticality of the criminal law, when we are trying to question the legitimacy, when we're trying to look at whether the how do you justify the punishment, how do you consider the state power is a legitimate power, the exercise of the state, exercise of the power by the state is a legitimate power. So the legitimacy is a big question mark. And when we talk about legitimacy, we need to look at the fairness, we need to look at the procedural fairness. We have to, and when we are trying to assess the procedural fairness, one of the most important thing is that whether we are getting into the dialogue with the subject matter on the aspects of the procedure, whether there is some amount of a negotiation, whether there's some kind of a discussions on the aspects of the punishment, on the aspects of the kinds of criminal sanctions that we are imposing, on the kinds of the procedure which is being laid down. So, and in that context, I think the critical criminal law issues are very relevant over here when we discuss these things. And as we all know, probably this is something which you all might have discussed in the previous days in the different sessions, that critical criminal law is nothing but is a part and it's a branch of critical legal studies. And these critical legal studies, which believes that law, this is something which is a very powerful base of critical criminal law, that law has inherent social biases. And specifically, when we talk about criminal law, this is more so relevant because as per this critical legal studies theory, we all know that it says that law supports the interest of those who create the law. And who create the law? Who has a power, who are powerful, they create the law. And when you are creating the law, you are not creating the law for the others who are on the other side of the table. We are creating the law for our own purpose, for protecting our own power. So basically, law is being created, law is being made, law is being drafted, legitimacy is being given to these rules and regulations just to support and protect the interest who are making this law, who are creating this law. And that's the reason that we always, there is an hypothesis that law always exists to support the interest of the party or the class that forms the law. And that is something which is very, very crucial over here. And that is something which questions the legitimacy, and how do we justify these actions which you are taking to support your own interest, to protect your own interests. And this is how we say that law supports a power dynamics which favors always historically who are privileged, and it always disadvantages to all those group of people who are historically underprivileged people. And that's the reason that who makes law, who decides the norms, who decides what is right thing to do and what is to be considered as morally wrong. They are those people who are powerful, those people who are wealthy, and they make the law for not only for their own protection, but at times law becomes the instrument of operation, so that they can maintain their own place, that they can maintain their own hierarchy in their own society. And this is the base, this is the fundamental base whenever we are trying to discuss any of the aspects of the critical criminal law. Now, when we talk about the critical criminal law, as I said, the legitimacy is the most important thing. Now, when we talk about legitimacy, the immediate question comes that how do we establish legitimacy? You can establish legitimacy only when there is a fairness, there is a fair dealing, when there is a due process, when there is not only the fairness, but there is a procedural fairness. And for the procedural fairness, dialogical approach is very much required. So let's understand first, we have all must have studied as a teachers or a group of teachers the dialogical approach of learning. So what is this dialogue means? So basically, the whole dialogical thinking has come from the literary text. It has come as a literary theory, and as we all know, it's any negotiated exchange of ideas and opinions. There has always been a negotiation. There has always been an exchange of ideas and opinions, which is something which is very, very vital in order to establish the dialogue. So dialogic theory always argues that the organization, it could be a system, it could be a justice delivery system, it could be the courts, it could be the police as an institution, it could be the courts as an institution, it could be the parliament as an institution, it could be anyone, any kind of an organization should be willing to interact with the public, with its subject matter, with for whom they are addressing that particular issue in an honest and ethical ways. And then only we can create an effective organization. So in these contexts, we need to ask to ourselves whether the courts are speaking to the audience, whether the police are speaking to the audience, when the parliamentarians are speaking to the audience. And, to some extent, we would say yes. We do have some kind of participatory mechanism when the laws are being framed, when the laws are being, placed, are being tabled before the parliament for discussions. The opinions from the general public is also being invited, and to offer their views. But how do we consider these as a dialogic process? That's a big question mark, because how how do you deduce the honesty and ethical process in terms of inviting the expression of interest, inviting the suggestions and a feedback from the common man, and how transparent is the procedure, that how feedback, who gives what feedback, who gives what suggestion, and how that particular feedback has been carried out and incorporate further in deciding the final authority of law. So one thing is that, in these exchange of ideas, there should be some scope of negotiation, and the negotiation scope only remains when there is an honest openness and honest, with all the kind of an honest dealings, you are inviting suggestions and ideas and opinions. So, as we all know, the dialogic principles are a core of aspects, or I would say the fundamental aspects for any living organization. It could be your own family, it could be any organization, it could be any governance system. There should be a dialogical principles which should be deeply rooted in the functioning, if we really wanted to make the system a sustainable system, long-lasting institutions. And when we talk about the principles of this dialogical approach, there are three major principles, and not three, but rather four. The four major principles are the potential, the participation, coherence, and awareness. So awareness is also one of the most important aspect when we really wanted to establish this dialogue with the audience, with the subject matter. So before we look at the dialogical approach in the criticality of the criminal law, I thought let's have a fair understanding of the theoretical understanding of the dialogic approach. Now, we all know, before I move to the questioning before I move to the legitimacy issue, we all know the way in which the criminal law has been attacked by normative framework, because there is a normative critique of the criminal law that this is something which is being considered as a repressive armory of the state. There is law has always been, and specifically the criminal law, and we have a number of examples even in Indian context, wherein the criminal law has become the repressive armory of the state, because it only contains sanctions to enforce the definition of right or wrong. And now who decides this right thing to do and who decides this is the wrong thing to do? What is the process through which, whether there was a dialogic process which is being followed or not, that is also we need to look at it. And these unilateral use of force by the state power in the name of establishing just and fair society. So we always look at the unilateral approach, why we are doing this thing, why we need to have a very strong and what I would say that very strict penal sanctions and stricter criminal laws, stricter laws, higher conviction rate, because we want to justify these things. We want to justify the unilateral use of force for establishing just and fair society. And then we don't know what is the limit of this power. You are using this power, the state is using this power for establishing just and fair society. But what is the limit of the state power that the society, that the state can use that power legitimately, either against the individual or against the group of people in the society? So that is also, and how do you measure the legitimacy? How do you assess the legitimacy? What sorts of conduct state legitimately make it criminal? How do you come to a kind of a conclusion? So, and at that context, the John Stuart Mill comes to our rescue, because he says that there has been always an extra political forms of legal control and extra legal forms of political control. And all these things you can find in the framework of the criminal law. Now, when we talk about the extra legal portion, that is something which is, I would consider that it is far more pervasive, because we all know that criminalization is a very costly affair, not in terms of the economic analysis of criminal law, but even in terms of the stigmatization that a person undergoes, the way in which the person is stigmatized, the way, the amount, how do you come to an economic analysis of the deprivation of the personal liberty of an individual when a person is being sent behind the bar during the investigation? How do you come to the cost factor, cost benefit analysis of that particular incident? So in any way, in a pure economic sense, or even if you're looking at economic as a qualitative parameter, in any way, criminalization is a costly affair. And that's the reason that we have to be extra sensitive, we have to be extra mindful whenever we are proceeding for the criminalization of any act. Because if this legal prohibition, we just have a discussion by Professor Nari on legal morality, I think. So when we talk about these when the state is trying to overstepping this moral legitimacy, then we have to ask the question that what is the compelling state interest in this? And we have n number of examples with reference to this. So when we talk about dialogical approach in the background of this normative critique, we need to ask to ourselves the moot points in the criminal justice administration system is that criminal justice generates social inequalities and the repression of powerless. There are n number of studies that has been already being done with reference to that how criminal law is always being uh, uh, of is operating against the interests of the poor person in the society. We have, and Professor K.D. Gore, Seleke, everyone has made a study that, look at the socio-economic profile of the people who are convicted and languishing in different kind of prisons. What is their socio-economic and cultural profile? And then I know this particular hypothesis will be able to prove this thing that, this criminal justice administration system always generates social inequalities, and it always represses the one who are powerless. And that's the reason that the critical criminologists always are concerned that how do you distribute the state power, state power in terms of the criminal sanctions, so that the social resource group, the different groups in the society we are being able to gain some kind of an equity and equilibrium between different groups of the society. And in that context, we have to discuss in these light, we need to discuss this what you call the dialogical approach. Now, as I said, for dialogical understanding, we need to understand first the legitimacy of the state power. So we need to ask the question that how do we come to a kind of a conclusion pertaining to the act which is to be considered as an immoral, or the act which is to be considered as an illegal, and that's the reason that it requires criminal sanctions. So when do we have a concept of shared morality in the society? Do we all share the same kind of a morality? Or do we have some kind of an estimation that which act would be considered as disgust or intolerance by an average individual, average Indian individual, if we are trying to look at in the Indian context? Because it's very difficult to assess and determine, because specifically today, if we talk about, we live in the era of manufactured movement. As we all know, we know Noam Chomsky. We live in the era of manufacturing consent, manufactured movement, manufactured consensus, and society by and large is polarized with the artificial insemination of ideas. There are all kind of ideas which are being artificially inseminated, and then people get carried away with these different kind of emotions, and then there are different kind of a manufacturing consensus that is being generated in the society. And in that context, how do you define that, whether there should be a mob lynching law, or whether there should be a law pertaining to the inter-religion marriage, or all kind of societal issues? So in these contexts, there are certain questions that we need to inquire, and these are the few questions which are very central to the theme of the legitimacy. I would call it as a reflective inquiry. And the first question is that whom does the criminal law address? Meaning thereby, when the criminal law, when the IPC, the criminal law, and if you're looking at Indian context, the IPC or the other substantive criminal law, if you're looking at criminal law in general, when any criminal law is addressed to whom? Is it addressed to the courts? Is it addressed to the police power? Is it addressed to the common man? It is addressed to whom? So whom does it address? To whom does the criminal law speak? When we talk about the legitimacy, they must be speaking to someone. They must be communicating to someone. They must be directing to someone. Whom they are speaking? Are they speaking to common people? And how do we measure the legitimacy and the legitimacy of a particular law? And what is the testing touchstone? Of course, when we talk about any provisions of the criminal law, we have Article 13 in the Indian context. The constitutionality of any provisions of law can be tested on the touchstone of the constitutional law. But in general, do we always come to the constitutional law to validate the criminal law provisions, or do we have some kind of an other testing touchstone through which we can also measure and decide the legitimacy? And the other question that comes into picture is that when we talk about criminal justice administration, who gets justice at the end of the process? Is it the victim who gets the justice? It is the state who gets the justice? It is the common man who gets the justice? Who decides who gets the justice? And then, if you look at the sanction part of almost all the criminal law, basically it would deprive you from your basic fundamental right, your life, your liberty, your personal liberty, movement. So all these issues are being deprived away when the criminal law sanction is being imposed. And at that point in time, whether can we look at criminal law as a civil rights document? Can you look at criminal law as a document, a struggle document for reinforcing the civil rights of an individual? So these are some of the questions that we need to inquire, we need to ponder upon, we need to try to reflect upon. Now, when we talk about legitimacy, as I said, the procedural fairness. Now, how do we establish and how do we measure the procedural fairness? Of course, we can have one of the essential element is that there should be some kind of a dialogical uh, principles that should apply in that procedure which we are imposing, which you are applying in a particular case. But then, do you look at and do you get the responses from the audience? Because for a dialogue, for any kind of for establishing any kind of a dialogue, you need to an audience, and how do you take the responses from the dialogue? So in that context, uh, as we all know, dialogical approach is not only required in lawmaking, but also in law defining, law amending, law interpreting, law implementing, and that whole process is something which is to be looked into as a holistic one. Now, uh, we know we I think we most of maybe aware about the good amount of work that is being done, which is seminal work by Tom Tyler, right? Because he has written a very good book, and based upon his own study which he has done, that why do people obey the law, right? Now, and if we try to answer this kind of a questions, we are trying to assess the legitimacy of the law, whether people obey the law because of the sanctions, or whether people obey the law because people feel the law is just, fair, and reasonable, whether people obey the law because people feel that this is the law which is being created, uh, which is being imposed on us, or which is being made for in consultation with us. There has been some kind of a dialogical process that has been carried out, and I have been the party to the process, and for that I have been already I have been already involved in this process, and that makes me morally responsible for someone who need to comply that law. So this kind of a study which Tom Tyler has already done, and which is a very seminal work, and he has come out with the issue that when we talk about the legitimacy, uh, Tom has come out with a very interesting insights that people do not obey the law because of the sanctions, but people obey the law because their own personal morality. Most of us, maybe, we are different kind of a people, and most of us, who believes that my personal morality is something I should be compliant of whatever is being said to me, because I have that trust and the confidence in the system. I believe that the just system and the system which is being imposed on me, or which is being set for me, is which is fair. There is a just procedure. There is a fair procedure. There is a just system. There is a legitimate system, and that system is being built up with my participation to it, and that gives them the moral obligations, and because of their personal morality, they what to call they obey the law. So in this context, it is very important to see to it that uh, I don't know whether we have done the similar kind of work, anyone has done the similar kind of work in India, in order to ascertain the facts that uh, whether people are obeying the law, how many people are obeying the law in India, and if at all they are a small percentage of the people who are being always obedient to law, what could be what is the force behind them to obey the law? So he says that people comply with the law not so much because they fear the punishment, because they feel that the legal authorities are legitimate and their actions are generally fair. So that perception, that belief, that presupposition is something which is very vital in order to decide the legitimacy of law. And this legitimacy you can only establish when there is some kind of a participatory framework. And in this participatory framework, I just would like to discuss, discuss the institutional legitimacy framework. Taylor has given this institutional legitimacy framework as well. So there are two kinds of a framework over here. The first is that there is a perception of procedural fairness amongst the minds of a people, and these perception of the procedural fairness gives the institutional legitimacy, and these institutional legitimacy leads to further compliance. This is one model. The other model could be that there is an institutional legitimacy which is already in existence, and this institutional legitimacy leads to perception of procedural fairness, and this legitimacy, since it is legitimate, people comply the law. So in different contexts both these model may prove to be workable. So when we talk about the procedural fairness, and specifically with reference to the institution procedural justice elements for the legitimacy of the judiciary, because when we talk about procedural fairness, it is not only with reference to the criminal procedure, it also with reference to all kind of institutions which are being attached with the criminal justice administration, the institution of court, the institution of police functionaries, the institution of lawmaking, the institution of law interpretation. So all court, police, parliamentarians, executives. So specifically, if I talk about the procedural justice issues, when we are discussing about the legitimacy of the judiciary, there are three things which are vital. The first and foremost is access to justice. How much accessible the institution is for resolving their own justice needs, for achieving their own justice needs. And then second is that the perceived impartiality in the minds of people, the perceived impartiality and perceived independence of the institution, independence of judiciary, perceived impartiality of the judiciary, that plays a very vital role in order to determine the procedural justice issues with the institution. And the quality communication, how well you are communicating with your subject matter. And in that context, I also would like to discuss about the participatory defense issues. Now participatory defense issue is also one of the most important element, because this movement is something wherein people who are facing criminal charges, their families and the communities, they all are get engaged, they all are get participate in this justice battle. Now whether do we allow them these participation from the point of view of the system, this is something which is very, very vital. Now, when it comes to the procedural fairness issues with reference to the uh, court and with reference to the police power, so at that point in time, there are different models. Vidhams have given three dimensions of legitimacy. Uh, so one aspect is the criteria of the legitimacy, and the other is a corresponding form of non-legitimate power. And on the basis of that, you may decide this thing. So when we talk about the criteria of legitimacy, the first thing that comes into picture is the conformity to the rules. That is all about the legal validity. Then justifiability of the rules in terms of the shared belief. The shared belief, it becomes very, very vital. There are so many things wherein there is not shared morality. There is no community sense of justice and community sense of immorality that prevails, and that against that community sense of immorality, if you're trying to impose something else, and we have seen the conversion law kind of an issue, the issues of what you call and specifically with reference to which comes to my mind that has happened recently is all about the interreligious marriage issues. And then the third part is about the legitimation through expressed consent. So if you have given your consent through the participation expressly, and then on the basis of that, that legitimacy can be inferred. And then on the other side, if you look at this thing, corresponding form of non-legitimate power, because when there is a breach of rules, and specifically breach of rules with reference to the constitutionality touched on, if you're making any law which deprives which your fundamental right. Legitimacy deficit, basically it becomes, it is an issue of the discrepancy of different rules amongst themselves. There are discrepancies between one set of rules and the other set of rules. And third thing is the withdrawal of the consent. So these are different models which are already available. Now, as I said earlier, that when we talk about the legitimacy unit and when we talk about dialogical, if you're establishing legitimacy through the dialogical process, at that point in time, you need to have an audience legitimacy. That is what we call as a subject matter to whom you are referring, the subject matter for whom you are making a law. And at that context, we have a lot of work that is being done by Jean Mark, that has been done by Bithan, and then they have come out with the idea that they both the authors, both the philosophers have tried to look at audience legitimacy with reference to the shared values and the consent to a given process. The consent is possible only when they are being involved, when they are being given an opportunity to participate in the entire process. So this is something which is very, very crucial when we are trying to understand the dialogical process in the criminal justice administration. And the lastly, which I would like to discuss about, because when we talk about it, procedural fairness, when we talk about legitimacy, when we talk about dialogical approach, what we are ultimately aiming is we are trying to democratize criminal law. And how do we democratize criminal law? Only through the community view of justice. And and of course you can definitely challenge the community view of justice, and you can also ask the question that whether it is relevant for the criminal law. But yes, it becomes relevant if you really want to democratize the whole process of criminal law. And the second question, that if at all it is relevant, then why should criminal law consider community view of justice? Whether it is something which will make the whole process more legitimate, or whether because at times it may happen that criminal law does deviate from the community view of justice. There may be number of occasions, and at that point in time, do you question the legitimacy if it is not being what you call, it is not being I mean, the community view of sense is not being considered. So democratizing the criminal law is one of the most ultimate goal of the dialogical processes that through which we are trying to study the criminal law. Lastly, I just would like to have few, because this is a this is a topic on which we are discussing about dialogue and participation. So I really do not want to have more monologue. I really want your input in your participation as well. Lastly, I just would like to focus on these philosophers, Anthony Botton, Tom Tyler, David Smith. Apart from, of course, Alan Norrie and Duff, the Anthony Duff has very specifically, very powerful question he has been posing, that whom with whom the criminal law is speaking, and how the criminal law communicate, communication of the core principles and core ideas of the state, how it is, what is the process through which that communication takes place, and how do you come to a shared exchange of ideas through which you come to some kind of a negotiating terms, is also very, very important. So with these, I just take a pause, and I would invite any questions, any query if you have. Thank you.
Thank you so much, ma'am. Thank you so much for addressing all of us. So Mr. Maris Port has raised his hand. So please.
Audible? Am I audible?
Yes, you are.
Ma'am, thanks for that great session, ma'am. Ma'am, especially, ma'am, if you look at the participatory, which we are talking about, legitimation, when we're talking about legitimacy, now majoritarian versus minoritarian, always there, that conflict. So if you go by the democratic view, then you can say that majoritarian, whatever they decide, let them decide. But what about the minoritarian? Because the subject is minority. So how we address that one, especially if you look at the conflict perspective. So whosoever wins, they will decide what the crime is. Even you take the current issue of triple talaq, whether we can penalize that or not. So here, whether the minoritarian is the subject of is the one supposed to be considered as pure audience, or we can take it as a majoritarian as audience, and in a way we are suppressing, or you can say that we are deciding the subject of that particular criminalization. What is your take on this, ma'am? How we address this one?
Well, it's a very good question. And I just would like to say one thing. We haven't used the terminology majoritarian views of justice. I know we have coined the word community view of justice. Now, when we talk about democratizing criminal law, if we have really understood the notion of democracy, when we talk about democratic principles and democratic processes, is all about when majority are thinking to protect the rights of minority. That is what the real democracy is. The real definition of democracy is not a majoritarian views. The real democratic notion is that when majority is coming to a kind of a conclusion, and they are coming together for the protection of the interest of the have nots, for the protection of the interest of the minority. And in that context, I do not look at these issues as a majoritarian views or a minoritarian views in that sense. But when I say it's a community view sense of justice, community sense of morality, and when a subject matter is related to a particular group of people or a particular community, what is their sense of morality and what is their sense of justice, what is their sense of fairness, when it is being considered by the majority of a people, it is what we call as a this is through the democratizing process we are establishing the legitimacy.
Thank you, ma'am.
Yeah.
Mr. Ajit,
Yes. Good evening, ma'am. Ma'am, when we talk about legitimation through expressed consent, now in a democracy as big as ours, it's not it's practically not feasible to gather consent of each and every person, whether they are in support of any legislative activity which is resulting in criminalization or not. So it's largely that we depend on maybe the views of experts like you, or let's say newspaper opinions, other jurists, etc. So, how do we ensure that this element of consent comes to us when we talk about legitimization? Because
I do understand we are not talking about the consent of every and each and every one individually. So, so first of all, let me clear that this is all about the philosophy. Philosophy is not, this is not something where we are discussing about how to operationalize these ideas. These are just a theoretical underpinnings. These are just in philosophical reflections. That is one thing. Now, when you come to when you talk about the consent, it is not a consent in the in the sense of verbatim as it is, but it is all about taking a sense, taking the a point of view of everyone. And for that, the most important thing for the country like us, as big as us, the generating awareness takes only number of years, and so many months, in order to reach out to people what we really intend to do, what is being proposed, what is your take on it, what do you think on these issue, what do you have to offer your suggestions, what do you want to convey, how do you would like to participate in this issue. For that, reaching out to people and bringing that awareness, first of all reaching out to people, bringing the awareness, and then creating that momentum so that they will come forward to offer their viewpoints is itself is a very big task. And that's the reason that it's a herculean task. It at times, um, it takes years together. And if you really want to run, and if you really want to run in the sense that if you really want to go in a fast pace, then probably you have to do away with all this kind of a procedural issues. You can't do that. But ideally, what we are talking about is this: reaching out to people, bring in awareness, let them know, and let them say what they want to say. Because if you say it is a democracy, it's not only the representative will, just the so-called representative will of the people which are deciding everything. The people themselves should be participating in the whole process, isn't it? So this is, we are discussing as a theoretical framework, how far practically is to be placed, and what are the mechanisms, and if we really want to impose this mechanism, for that, the kind of a literacy, the kind of an the kind of operational mechanism which we have to put into practice is it's altogether very different kind of a discussion.
Thank you, ma'am.
Yeah.
Ma'am, actually, Nandini ma'am has posted some comments in the chat box. Nandini ma'am, would you like to ask by yourself?
Yes, sir. Thank you so much. Ma'am, basically, when we have a social contract which we have entered since long time, is it not by itself giving it to a community that I'm giving you a legitimacy to rule me, and I have given my safeguard to you, so you take care of me? Is it not the meaning of telling that this is legitimizing for the criminalization also, ma'am?
How do you decide? Yeah, I agree. But how do you decide? What do you think about your taking care? What is the sense of yours that you are being taken care of? And what is the sense of the others that they are taking care of you? Whether, how do you define that your understanding of your taking care and their understanding of their taking care of yours is the same one? How do you define that your sense of well-being is matching with the sense of well-being of the one who has been taking care of you? How do you decide? Because at every occasions in the changing scenario, it gets changed. So unless and until they come at every time, forget about, this is the whole issue. I just would like to give a small example. Even at our home, when our kid, our sons and daughters, they are small, at the end, at the age of 8, what they may be liking in dinner, probably at the age of 10, they said, no, I don't like, this is not my favorite food, my favorite food is being changed. I'm just giving this very simple and small example. So what do you think is good for you, whether they also think, your sense of goodness and sense of justice for you, whether that matches with the sense of justice of the others or not. That is something. And whether it is always true at every occasions, at every, in all important aspects of life and the governance, is the question. Because
Ma'am, we see that through dynamism of law, no, ma'am. That is why we see that there are judgments which have been dynamic enough to see that it goes along with the changes that are happening. And we also have seen that in the legislation making, law making also. I think, is that not enough to say that this is what legitimacy meant
yes,
for criminalization?
that's fine. Again, that's what I'm saying. This is just a theoretical and philosophical reflections. Because when we talk about dialogic, it is at every occasions, at every point in time, you need to be asked. Your sense of your point of view is to be taken care of. You should be, then only, because you are the subject matter. This is going to be affect you as a citizen, you as the common man. On your views are not being asked, and without a dialogue, how do you consider them as a legitimate? Because as we all know, in a simple terms, I always believe that whenever I have to give an assignment to the students, I would always like to ask the students themselves, bolo ye assignment kab submit karoge, what should be the deadline? When all of them, they say, okay madam, the deadline could be at the end of this month. Okay, fine. Is it fine? Deadline is the end of month. Yes madam. Now, on one, you have a dialogue, you have a shared negotiation, you have a shared ideas. Now, if anyone would like to seek an extension, he would think for twice. I have participated, I have given a consent, and then that legitimacy is established. Without being now asking for extension would be something which would be shameful to me. I mean, it's a very simple thing. So, that your involvement, your participation, your say would be that whole dialogue would make it more legitimized. The decision would be more legitimized. This thing, and you be morally obliged to follow that. That is what the whole point is.
Thank you, ma'am. Thank you so much.
Lovely Singh. So ma'am, actually Lovely Singh has posted a question in the chat box. Okay.
Hello, ma'am. Good evening, ma'am.
Good evening.
Ma'am, my question is that does the implementation of laws in the community proves its legitimacy? Because like a democratic society like India, laws are made for the victims. Whenever we find someone a victim, the laws are created for them. But in actually, the justice is not so provided. So I think that the legitimacy fails here because the result of the laws are not providing justice to the victims. The victims remains on the same level
Yeah,
because
yeah. So, you can't say that, particular law is being implemented, so the legitimacy is being established. It is a legitimate law because it is being implemented. Because again, the question of procedural fairness, question of dialogue, the question of its authenticity, question of its participatory mechanism would be come into questions. And then sense of satisfaction and sense of justice to the victims or to all the subject matters who are the part of that entire event. So unless and until that sense, the view, the sense what of the subject matter of the audience is being sought, how do you say that it is something which is a legitimized one? So implementation of law, that's what I said. We haven't had this kind of a study in India, like, why in India, if at all, people are obeying the law. First of all, the question comes that people are not generally being having so much an inclination to obey the law. They would always think that, how do we, get rid, because we always look at the shortcut. There's some kind of a cultural context with reference to this. So most of us, or many of us would have the shortcuts, would always try to, fade away from the following of the laws. So, we don't have any studies. If at all, there are 30% compliant people in this country. Why do they comply? Because of their personal morality, because of the way in which they are, because of their cultural upbringing, or because of their own ethical understanding, or because they believe that this system is just and fair and we should obey it. So what are the reasons? We do not have this kind of surveys of the in the Indian context. And probably when we do this, if someone comes forward and do even for the smaller population as a litmus test, as a pilot study, would come to know about it. But unless and until people are being involved just with the implementation, you can't say that legitimacy is being established.
thank you very
Ma'am, actually Dr. Sangeeta ma'am wants to share something. Dr. Sangeeta ma'am.
Good evening, ma'am. The point is, as it is in support of the earlier participant, like sometimes the laws are also made just to pacify the people, like in Nirbhaya case. Like they made it in haste and then they really wanted to implement it in that way. And then what happened, they retrospectively they applied it. So that was, that was really wonderful at that time, or maybe it was not acceptable. Like, how can you do it retrospectively? That is
Yeah.
my point, how we can just do it under the pressure of the public. And she was absolutely right when she said that it was not for the victim at all. It was just for, to pacify the public.
Yes. So in that context, so you mean to say that whether the community view of community sense of justice is always to be considered as a legitimate? Is it the question?
No, ma'am, this is not the question. The question is like community may be asking or demanding anything, but we have to look into the principles of criminal justice. Can we apply it retrospectively? If we can't, then we should not do it in one particular incident at all.
Yes, yes, yes. So, there are certain core principles which are to be observed, and, and who are those people who are giving this kind of an input, whether they all are well aware of who are they, what is the stature, what is their understanding about law, what is their understanding of the right thing or the wrong thing, wrong. All these things is to be taken into consideration.
Dr. Kalpana, ma'am.
Good evening, everyone present here. I wanted to respond Miss Lovely Singh's question actually. She talked about criminal law justice system. Actually, foundation of criminal law is based on a different premise altogether. It does not substantially addresses victims' pain actually, what we see. Since state is enforcement agency of criminal law, the first agency to deal with the operation of criminal law or enforcement, and giving a message to the whole of community about we would protect against the objectionable behavior or offending behavior of offender. I think that is my understanding about it. We forget what is the victim psychology here. There is no mechanism devised under criminal law. Though we are working on it to talk about it, we are in a nascent stage where Parivartan Bhalai Kendra in acid attack case, we do have Supreme Court has issued the guidelines to the states to formulate to victim compensation scheme in case of acid attack victims. So there are certain enactments, not enactment, but certain provisions have been incorporated by Criminal Law Amendment Act towards compensatory jurisprudence towards victims of crime in certain crimes only, where the fine can be given to the victim. Otherwise, it is all about regulation of human behavior कि चोरी नहीं करनी है, डकैती नहीं करनी है, rape नहीं करना है, and it talks about the consequences of what you would be facing if you commit and convicted.
So the question is that you are perfectly fine, but the question is that, whether whatever the consequences which are being imposed, whether it was something in the consultation with the people at large. So this is all about the at the time of making the law, at the time of processing the law, at the time of implementing the law, at the time of interpreting the law. How do you take the sense of people? That is what
This
the
is the
issue that
primary
what we are
objective to
addressing
send
over
a
here.
message to the society about the action of the state and judicial process also. A judiciary is also more conscious to send a message. Actually, if someone does this, that would be the consequence and fate of the offender. I think we are not thinking more about victim. We are thinking about what society is thinking about that process and action by the state. उसको arrest नहीं किया, उसको arrest नहीं किया. Nobody is asking victim whether victim is actually looking for arrest and severe punishment. As we were talking about, victim might be looking for an apology and settlement and restoration or compensation, but state does not allow. Court does not allow.
Yeah. That's the reason we discussed about the participatory defense on the part of the victim. So, how do the victim and the victim family members can also get involved? And we have the family support, the concept of family support group, who would be supporting the victim, and how do they participate in the entire at the time of criminal adjudication process. So uh, that is what the theory talks about that is what the legitimacy theory talks about.
Thank you, ma'am. Thank you so much for sparing out your valuable time, ma'am.
I want to share something on it.
Please, ma'am.
Actually, the victim is a main key role player, and who is in the whole system is just a forgotten man, because everyone is talking about the offender. So this is the main point that we have to think over it.
Yeah, I am also putting the same point. And sometimes accused is also into the shoes of victim.
Right.
So all are looking at him as if a convicted person without being, giving him to trial. If you remember Riya Chakravarti's case, where media, intruded their mics into her arms, that was quite offensive behavior from the media without giving a fair chance to be listened to the agencies of investigation. She was subjected to the crime actually, which is unrecognized. And people were enjoying that harassment and intrusion into her privacy. Because we are looking at the accused. And accused steps into the shoes of victim during that process only. And one more example of Shashi Tharoor, if you remember, he was forced to sit for hours and hours for interrogation. He is also a victim of the process because we want to send a message. Actually, we are more bothered about a message towards society and community, not about victim or not about even accused also. Nobody is bothering about accused or nobody is bothering about victim.
Kalpana ma'am, I'm sorry to interrupt, but we are falling short of time. So I request you, if you have any question, then you may please send an email to us.
Okay.
Very sorry to interrupt you, ma'am. Over to you, Amit.
Yeah, so thank you so much, ma'am. Thank you so much, Professor Pubi. And thank you for addressing the questions of the participants as well. And thank you, participants, for participating.